The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker. I speak on Bill C7 at report stage. This legislation illustrates the dangers that arise when a government puts blind ideology ahead of evidence-based decision-making. The road that we have the nightmare of this bill and the road that has led to today, Madam Speaker, began when a Quebec Superior Court judge issued the Trudeau decision. And in that decision, that lower court judge determined that the most important safeguard in Canada's medical assistance in dying regime, namely that death be reasonably foreseeable, was unconstitutional. Now, that decision, again, was one judge in one province. It is not binding in any other province. It does not bind the Quebec Court of Appeal. Indeed, it is a non-binding decision. Now, Madam Speaker, in the face of that, one would have thought that the Attorney General, whose responsibility it is to uphold laws passed by this Parliament, would have appealed the decision. After all, we're talking about a decision that removes the most important safeguard that was part of legislation that had been passed a mere 3.5 years prior to the issuance of the Trudeau decision. But instead, Madam Speaker, this Attorney General put ideology ahead of the interests of vulnerable persons and did something that is virtually unprecedented. The Attorney General did not appeal the decision and instead recklessly tabled Bill C7 that eviscerates key safeguards, including the most important safeguard, namely that death be reasonably foreseeable. And in so doing, the Attorney General seeks to radically transform Canada's medical assistance in dying regime from something where it is deemed appropriate to deal with or address suffering in death to now providing death to deal with suffering in life. Madam Speaker, and in so seeking to so radically transform Canada's medical assistance in dying regime, the Attorney General has preempted a mandated parliamentary review provided for under Bill C-14. The Attorney General has proceeded with completely inadequate consultation, ignoring important voices that represent vulnerable Canadians, and most importantly, the voices that represent Canada's disabilities rights community. When 72 national disabilities rights organizations wrote to the Attorney General and pleaded with him to appeal the Trudeau decision, he ignored them. Their pleas with this Attorney General have fallen on deaf ears. Now, why, Madam Speaker, is the disabilities rights community so concerned with Bill C-7 and in particular the removal of the criterion that death be reasonably foreseeable? Well, very simply, Madam Speaker, when that criterion, that safeguard is removed, it means that someone who suffers from a degenerative disability could be eligible for that very reason, despite the fact that they may have years, if not decades, to live. The disabilities rights community on that basis has said in clear and unequivocal terms that they believe this bill stigmatizes persons with disabilities. As Krista Carr, the executive director of Inclusion Canada, said, this is our worst nightmare. As Catherine Ferrazzi, disabilities rights advocate and former Ontario Human Rights Commissioner, said before the Justice Committee with respect to Bill C7, why us? Why us? And why, Madam Speaker, in asking that question, is this government proceeding to discriminate against the rights of persons with disabilities by depriving persons with disabilities protections against premature death afforded to all other Canadians outside of an end-of-life context, and in so depriving those rights specifically to persons with disabilities, significant questions have been raised about the constitutionality of Bill C7 and whether it in fact, as a result of discriminating against persons with disabilities, would therefore and obviously violate Section 15 of the Charter. But those questions, those concerns were again completely ignored by the Attorney General, who puts the ideology of ableism first. So blinded is the Attorney General that he ignored not only concerns from the disabilities rights community, but from the UN Special Rapporteur on the rights of persons with disabilities, who has said that this bill violates international human rights norms. So blinded by ideology is this Attorney General that he ignored the UN Human Rights Commission, which this government is rather fond of, which has said this bill runs afoul of the Convention on the Rights of Persons with Disabilities, and in particular, Article 10. And Madam Speaker, just when one thought it could not get any worse, we learn today that it in fact has, with respect to the motion that the Attorney General tabled in this House, which, among other things, essentially accepts, with some very minor tweaking, radical Senate amendments, including one that would provide that one would be eligible for medical assistance in dying for having solely a mental illness. This is a radical, radical change. And despite the fact that this issue has not been appropriately studied, the Attorney General has said it is now a fait accompli. Despite the fact that we don't know how to predict irremediability in the case of mental illness, despite the fact that we don't know if someone's mental illness is the basis for their request, is a symptom of their mental illness, their request for medical assistance in dying, and despite the fact that we don't know whether someone's mental health suffering could be alleviated by health and other social supports. Madam Speaker, this bill is a reckless, dangerous piece of legislation that puts some of the most vulnerable persons in Canadian society at risk. It must be defeated.
Questions and comments? The honourable member for Victoria.
Thank you, Madam Speaker. And, the Senate in this case has exceeded their mandate. It's extremely concerning. They prejudged the review. I think it's extremely concerning for people in the disability community. People in the disability community have also expressed that there are just not adequate income supports there for them to support them. It makes this whole issue even more complex. And I'm curious if the member would agree that A, the Senate has exceeded their mandate in this case, and B, that we need to have a national income program for people with disabilities to bring them up to a livable income at this time.
The honourable for St. Albert, Edmonton.
Well, I want to thank the honourable member for Victoria for her question, and I would concur with her that the Senate has exceeded its mandate in going far beyond the scope of what was in Bill C-7, and that's why I have to say I'm shocked that the Attorney General didn't outright reject the amendment with respect to mental illness being a sole criterion for being eligible, or solely having a mental illness being eligible, therefore, to have medical assistance in dying. And despite the fact that there's a lot of things we don't know, one thing we do know is that 4,000 Canadians each year die of suicide, 90% of whom suffer from mental illness. And so the question becomes, how many persons with mental illness will have suffered a premature death as a result of this legislation?